Hello friends, in the series on the income tax cases, today we will discuss a very important issue. Nowadays it is seen that the department makes searches on various persons, the department do survey, and in those searches and surveys, the statement of those persons on whom the survey or search is made are taken. And whatever the transactions are related to those persons or whatever the documents are found at the survey or search of those persons, on the basis of those documents, in number of the cases are reopened and the additions are made blindly just on the basis of the statements. What is the sanctity of these statements? Whether these statements should be backed up by the proper evidence, whether these statements can be relied without giving an opportunity of cross-examination or without testing or proving those statements. What is the fate of those additions? This issue has been taken by the Honorable Allahabad High Court in the case of Principal Commissioner of Income Tax versus P&C Infratech Limited. This case has been reported in 461 ITR at page number 92 and the date of the judgment is 30th November 2023. In the present case, the assessee has received share capital, or in other words, the assessee has issued shares to 3 entities, and at the later stage from whom this share capital has been received, search was made by the revenue department and statements were taken. On the basis of those statements, because the persons from whom the statements have been taken, they have admitted in those statements that the companies to whom they belong are involved in some fictitious transactions like accommodation entries and other malpractices. On the basis of those statements, the additions of the assessee was made. The important point in this case was that when the assessment proceedings were going on, one person from whom the statement was taken was called by the assessing officer. When the statement of that person was again taken, that person showed his ignorance about the business transactions of the companies from whom the transactions have been done by the assessee. In other words, that person was not able to prove or disprove the transactions. In other words, we can say that that person claimed total ignorance about the transactions. The rest of the persons from whom the statement was taken were not tested before the assessing officer, they were not examined, they were not cross-examined, and just on the basis of the ex-party statements, the additions were made. When this matter came before the CIT appeal was of the opinion that in the absence of evidence, the additions of the assessee cannot be made just on the basis of unproven and untested or ex-party statements. And when this matter came to the tribunal also upheld the order of the CIT appeal. The matter came before the High Court and the High Court said that in the present case, no material witness was examined during the assessment proceedings and the investors from whom the assessee has done the transactions have shown the investments into their balance sheet, and the High Court was of the opinion that when the assessee has submitted the basic documents to show the identity, genuineness and credit worthiness of the transactions, then the burden shifts on the revenue to prove that the transactions are bogus or not genuine. In the present case, the High Court was of the opinion that burden to prove now rested on the revenue to prove that the transactions are not genuine. Friends, this case is very important because nowadays it is a very general practice of the department that whatever the statements they have got, and in those statements, if the slightest of the connection of the assessee is there, whether in the form of ledgers which are found at those places, then just on the basis of those ledgers and some transactions are appearing in the bank accounts, the additions are made of the crores of rupees. This practice is not as per the law which has been laid down as per the admissibility of the evidence of the statements, and this practice is not as per the exact law which has been laid down by the various courts in their various judgments. So unproven, untested ex parte statements do not have any value until and unless they are again examined at the time of assessment proceedings or the assessee is given the fair opportunity of cross-examine those persons, because from whom these statements are taken are the witness of the department, and the witness should be examined by the assessee if the additions are made in the file of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus P&C Infratech Limited, and this case is reported in 461 ITR at page number 92. The date of the judgment is 30th November 2023. Thank you, friends.